So first, I'd like to thank the LA County Commission for allowing us to come today and present. This wouldn't be possible without all the guidance and tireless efforts of Wynn, as you see her, to pull this together, and her team at CHIP, so really thank you. The panel presentation today is going to include an overall overview of key federal and state law protections from discrimination, particularly those that are applicable to people living with HIV. It includes discrimination in multiple settings: healthcare, housing, employment, and public accommodations. And we're going to be covering a little bit of recent data on HIV-based discrimination here in LA County to kind of set the stage, followed by presentations from my esteemed panel here, which includes the overview of the laws and the remedies available for those who may have faced illegal discrimination on the basis of their HIV-positive status. So my name is Ayako Miyashita. I have had the pleasure of being here before. I served as the HIV Law and Policy Fellow at the Williams Institute, and am now representing the Williams Institute as this year's Law Teaching Fellow. Today I'm wearing my hat, however, as the director of the LA HIV Law and Policy Project, which is now based out of the Clinical and Experiential Department at UCLA School of Law. For the past year, I've directed the work of the Legal Services Collaborative, serving Angelenos living with HIV who may be experiencing an unmet legal need. We have a core set of legal partners in this work, including the Williams Institute, the LA County Bar Association AIDS Legal Services Project, led by Lariana. I have to point her out because she's been a part of this community for 26 years doing this work. Intercity Law Center, who is funded by HAPWA. Public Counsel, our team there that helps a lot with our public benefits work, in taking a lot of our cases in the public benefits area, now in the traffic and citation area. Disability Rights Legal Center, who was the first organization to host the centralized intake for LA Help. Vetsetic Legal Services, serving the city of West Hollywood, the ACLU of Southern California, and Lambda Legal. We partner regularly with service providers. I see some of you here. APAIT, APLA Health, Being Alive, LA Family AIDS Network, which is now at UCLA Health, and Main Street Clinic, and the folks at Hubert Humphrey Comprehensive Medical Center. So I'd like to introduce our panel for today before we get started. From the United States Department of Health and Human Services, the Office for Civil Rights, representing the Pacific region, we're joined today by Michael Leos. Michael is the regional manager for the Pacific region. He's responsible for the overall investigation and resolution of all complaints and compliance reviews arising out of the Pacific region. The Pacific region includes those entities that are covered by those entities that receive Health and Human Service funds, oversees HIPAA and Section 1557 covered entities that are located in the states of Alaska, Arizona, this is going to sound like a song, Alaska, Arizona, California, Hawaii, Idaho, Nevada, Oregon, Washington, and the U.S. Pacific Territories of American Samoa, Guam, and the Commonwealth of the Northern Mariana Islands. Mr. Leos is a graduate of the University of California, Berkeley, and the University of Southern California Law School. Michael's admitted to the State Bar of California and also the United States Federal District Court Central District of California. We are also joined by Megan Yalorda, who is an Equal Opportunity Specialist at the U.S. Department of Health and Human Services, Office for Civil Rights, also in the Pacific region. In 2005, Megan completed her Master's in Public Health and Global Health at Loma Linda University. She began her career in public service with the City of Kansas City, Missouri Health Department. And while at the Health Department, Ms. Yalorda worked as a health inspector in the Food Protection Program and later as a recruiter for the Public Health Ambassador Program. Ms. Yalorda joined OCR in 2009, focuses on civil rights and health information privacy cases. She received her bachelor's in dietetics from Oakwood University, again, her master's in public health from Loma Linda University, and her JD from the University of Missouri, Kansas City. Ms. Yalorda is a member of the Missouri Bar Association. We're also joined today by Angela O. and Paula Perlman of the California Department of Fair Employment and Housing. Angela O. is an attorney mediator at the department. Her work focuses on providing individuals with alternative dispute resolution processes that facilitates early resolution of charges of discrimination. Ms. O believes that her work as a trial lawyer, a community-based advocate for civil rights, and her experience with conflict resolution provide a strong foundation for her current work with the department and is an essential and complementary alternative to litigation. Paula Perlman is the Assistant Chief Counsel of the Department of Fair Employment and Housing. She works with a team of lawyers litigating high-impact cases on behalf of the state of California. In the areas of housing and employment, she's also the former executive director of the Disability Rights Legal Center, a cross-disability civil rights organization. For this panel today, we're going to present a little bit of data on HIV-based discrimination in LA County. Will be followed up by presentations by both teams here, which will cover law and remedies. We'll follow up with a Q&A and hopefully have an opportunity to hear from the commission and from the public. Any questions or any follow-ups at that time. So really quickly, so we can get on to our panel. In my work at the Williams Institute, we conducted a legal needs assessment of almost 400 people living with HIV here in LA County. That legal needs assessment was a way of determining what were the unmet legal needs that continue to impact and affect people living with HIV in our county. In that legal needs assessment, we asked questions about discrimination. We particularly asked questions about discrimination in the settings of healthcare, employment, and housing. What we found was that in the past year, at least 21% of the people responding had experienced some distinct event related to discrimination in one of those three settings. And in the past 5 years, prior to the survey, to taking the survey, that 31% of those individuals had experienced some event leading us to believe there was some form of discrimination that the person experienced as a result of their HIV status. Now, the needs assessment is available online, so I won't go into it too deeply, but I will say that the responses were different, particularly among specific subgroups, including transgender women in the context of healthcare, perhaps not surprising, and results for gay and bi-identified men in the context of employment. So I really do urge you to go ahead and take a look at that needs assessment so you can get a feeling for what it is that we were able to find in a recent legal needs assessment. We also did a FOIA request, a Public Records Act request, from various state and federal agencies. That data has not yet been published, but I will tell you that, generally speaking, LA County has seen the bulk of the complaints, or the bulk of the complaints in California have come from LA County. At least here in the state of California, LA County continues to be an area that gives rise to a higher proportion of complaints than other parts of the state of California. We had a dental discrimination study that was done in 2007-2008 and a previous testing study that was done from 2003 to 2006. Some folks that have been on the commission were actually a part of this, including Drs. Unai and Tom Donahoe. And in that study, what we found was that while 5% of the dental providers surveyed had a blanket policy of refusing to treat people living with HIV, in fact, it was other providers as well in the healthcare sector that also had blanket policies denying services to people living with HIV. That included 26% of surveyed plastic surgeons, 46% of skilled nursing facilities, and 55% of the obstetricians that were surveyed. So while this data is not new, and in fact, we may want to consider looking at this again, I think that what this data does is gives rise to a push for further inquiry. As the director of LA HIV Law and Policy Project, LA Help, we've seen a rise in the number of folks calling us, claiming that they have experienced discrimination in multiple settings. So this is in large part why we wanted to bring the panel on today, to talk about this, to talk about the law, to talk about the remedies. And so I'd like to get started. Michael, Megan, thank you for traveling from San Francisco to join us today. I'd like for you to come up and share information with us about OCR.
So thank you, Ayako, and thank you. Can you all hear me okay? Yeah. To the commission, glad to be here. So I think I have about 10 minutes, so I'm going to speak pretty fast. And I'll tell you a little bit about our department. We're at the Office for Civil Rights. We're part of the U.S. Department of Health and Human Services. Just want a quick show of hands. How many of you have actually heard of us? Okay, so some of you have. Okay, all right. So we are, next slide. So we are part of the U.S. Department of Health and Human Services. Every federal agency actually does have an Office for Civil Rights. So the Department of Education has one, Department of Labor has one, Department of Justice has a Civil Rights Division. So each department has sort of a Civil Rights Division which enforces civil rights within the particular division. So we're in charge of Health and Human Services, health programs. We enforce a number of civil rights laws as they relate to recipients of federal financial assistance. I'll talk about what that means, public entities. And we also enforce the HIPAA privacy, security, and breach notification rules. We have 8 regional offices, and we are located in 11 locations. And in the next slide, we'll actually show you what our regional offices are. So for those of you in California, you fall within the Pacific region. And actually, California is the majority of our complaints that come into our Pacific Regional Office come out of California. In fact, over half of our complaints come out of California. Even though we do have jurisdiction over in the next slide, you'll see that we have, and as Ayako mentioned, we have responsibility for all of the other states. So basically, as a friend of mine said, we have jurisdiction over our border with Russia and border with Mexico in the Pacific region. We also have the Pacific territories. But those are the states which we cover. So if a complaint arises out of the state of California, it'll come to our office, the Pacific region. So if you go to the next slide. So we have a wide array of enforcement and compliance activities. The number one area is complaint investigation. So if we get a complaint, anybody is free to file a complaint with our office if they feel they've been discriminated against or if they feel that there's been a breach of their privacy, private health information. They can file a complaint with us. We actually have a complaint portal on our website, which makes it very easy for someone to file a complaint. The other way we also get complaints, for those of you who are part of legal organizations or part of community-based organizations where you're seeing systemic issues, that's another area where we actually get a lot of complaints on behalf of people, particularly if they're limited English proficient, or if they're disability issues, or just systemic issues in HIV, for example. We will get complaints from organizations on behalf of a class of people, so we take those complaints as well. We also have the authority to open up a compliance review in the absence of a complaint. That could be based on, there could be media reports that there is discrimination taking place, so we might open a compliance review in that regard. Under our regulations, we are required to try to seek voluntary resolution of a complaint. But we do have formal enforcement capability as well, and we'll give a couple of examples during this presentation. In the HIPAA arena, we also conduct audits. So for those of you that are working with HIPAA privacy, for example, you are aware of our audit program. We actually started phase 2 of that. And of course, we also do outreach and public education, and we'll talk a little bit about our new law that we started to enforce. So if we go to the next slide. I think that I just covered this. So filing complaints, one key thing about filing complaints, one thing I just want to point out is that complaints should be filed within 180 days of when the complainant knew or should have known that the act or omission occurred. There is an ability to waive that for timeliness, but generally speaking, we like to have complaints filed within 180 days. So if we go to the next one, this just basically tells you how we can resolve complaints. Voluntary resolution is the way that we try to, again, we are required by our regulations to try to resolve complaints through voluntary resolution. A lot of them are resolved informally, but again, as I said, we do have a lot of enforcement mechanisms available to us. So if we go to the next one. These are the major laws that we cover. Title VI of the Civil Rights Act of 1964. For disability purposes, Section 504 of the Rehabilitation Act of 1973 is a major law that we enforce, which prohibits discrimination on the basis of disability, which includes HIV/AIDS. Title II of the Americans with Disabilities Act of 1990. And then the other key one is Section 1557 of the Affordable Care Act. That's actually a relatively recent law regulation that we've started to enforce, and that prohibits discrimination on a wide array of bases, and I'll talk a little bit more about that because it does increase our enforcement responsibility, and it does cover more people. So if we go to the next slide, I'm going to run through these pretty real fast. Whenever we get a complaint, we have to establish jurisdiction to make sure that we actually do have authority over it. So one of the key components here is making sure that there is federal financial assistance. So if we go to the next slide. So in order for us to be able to cover a program, that program has to receive federal financial assistance for civil rights purposes. Under 1557, we actually have broader authority to reach covered entities. So again, that's the first thing we look at is whether we can cover it because they're a recipient of federal financial assistance. And the key idea there is if you're getting money from the government to provide a service, to provide that service without regard to, without discriminating against individuals who are eligible to receive those services. So if we go to the next slide, federal financial assistance means assistance in the form of any grant, loan, or contract, and that's actually pretty expansive, actually. So we do cover a lot of different programs. And those are just some examples. So it does cover a lot of healthcare providers, hospitals. It includes even Head Start programs, TANF programs. So it's a wide array. We actually have a wide net that we can cover. So next slide. These are civil rights authorities. Title VI of the Civil Rights Act prohibits discrimination on the basis of race, color, national origin. National origin does include limited English proficiency status. So someone, if you're unable to understand English or communicate in English, you are protected under Title VI, and there are obligations. Section 504 of the Rehabilitation Act of 1973 prohibits discrimination on the basis of disability. And we also have authority over the American with Disabilities Act, ADA, Title II, and this applies to, in the next slide you'll see, state and local government agencies. So again, for this particular law, FFA does not have to be established for us to assert ADA Title II jurisdiction. So 1557, I do want to spend a little bit of time on this one because this is new. It's the non-discrimination provision of the Affordable Care Act, and it prohibits discrimination on the basis of race, color, national origin, disability, age, or sex. We've underlined sex because actually it's the first federal civil rights law, major federal civil rights law to cover sex broadly. So it prohibits discrimination on all of these bases in any health program or activity that receives federal financial assistance from HHS or is administered by an HHS agency. And it also extends non-discrimination protection to the marketplaces. So marketplaces are actually covered now, and they are subject to this non-discrimination provision. So if we go to the next slide, sex discrimination under Section 1557 includes discrimination on the basis of sex. So that means that a health insurer cannot charge more to a woman, for example, for health insurance as opposed to a man. That would be one basis. Or you cannot discriminate against someone because they're one particular sex as opposed to another. But it also includes gender identity and expression. So this means that if you're a transgender, and I think Ayako mentioned we do see a lot of these complaints on behalf of persons filing because they're transgender status or because they're being discriminated against because they're transgender. It actually does include that. It also includes nonconformity to sex stereotypes, so traditional concepts of masculinity or femininity, meaning that you're expected to act like a man because you're a male, or act like a woman, or have these sex stereotypes. That's prohibited. And we actually have already begun to receive a lot of these complaints in the area of sex discrimination, including gender identity. And we've started to investigate those. It's a relatively new area of the law. It's a new law for us. And again, if you do work with transgender individuals, I encourage you to look at our Section 1557 regulation. We do have a lot of information on our website about that. But again, you are free to file complaints on that basis because we're starting to look at those very closely. And there are a lot of novel issues that are coming up in that area. So again, that's our newest law that we actually enforce, 1557. and it does expand, and it does cover. One thing about this, it does not cover discrimination on the basis of sexual orientation per se, but OCR has made a policy decision. If we get a complaint on the basis of sexual orientation only, we will basically look at the complaint and see if we can get to that or investigate it if it falls under sex stereotyping. So again, and I won't cover this right now because of time, but it does not cover sexual orientation per se, but we are trying to get to some of those complaints under the sex stereotyping provision. So we go to the next slide. We also do have jurisdiction, limited jurisdiction over Title IX of the Education Amendment Act of 1972. That's another major law, but it's a very small part of what we enforce. Another big area for us is health information privacy. So this is actually the #1 area for us in terms of volume of complaints. So we have responsibility over HIPAA, and we have, within HIPAA, there are a lot of different, there's the privacy rule, security rule, and I'm gonna have Megan talk about that. But again, it's also protection, it does cover protection. What HIPAA does, it provides protections for health information, which includes all types of protected health information, but it also includes HIV, AIDS status, and we're gonna give you an overview of that. I'm gonna turn it over to Megan to talk about that, our HIPAA provision.
All right, thank you, Michael, and good morning. So let's get started here. So the HIPAA privacy rule. So the HIPAA privacy rule applies to covered entities. Covered entities are essentially healthcare providers who transmit health information electronically in connection with a transaction for which there is a HIPAA standard. It also includes health plans, healthcare clearinghouses, and business associates as well. So business associates include agents, contractors, and others who are hired to do the work of or work for the covered entity, and such work requires the use or disclosure of protected health information. In this case, a business associate expressly includes health information organizations, e-prescribing gateways, and PHR vendors that provide services to covered entities. Subcontractors of a business associate are also defined as a business associate. Business associates are directly liable for certain violations of the privacy, security, and breach notification rules. The privacy rule requires satisfactory assurance in the form of a contract or a business associate agreement that a business associate will safeguard the protected health information and limit its use and disclosure. So what is covered? Well, protected health information is essentially individually identifiable health information that is transmitted or maintained in any form or medium that is held or transmitted by covered entities or their business associates. Health information does not include de-identified information that's de-identified per the safe harbor or expert method. It does not include employment records, and it does not include FERPA records, and FERPA is the Family Educational Rights and Privacy Act. So some of the key points on uses and disclosures. No use or disclosure of protected health information is allowed unless it's permitted or required by the rule. So there's two main categories: required disclosures and permitted disclosures. The required disclosures are disclosures to the individual or his or her personal representative who is the subject of the personal health information, or to the Secretary of HHS to determine compliance, which is our office. All other uses and disclosures in the privacy rule are permissive. Covered entities may provide greater protections, however, than what is outlined in HIPAA. So these are some of the permissive uses and disclosures. For example, disclosures for treatment, payment, healthcare operations, disclosures with an individual's opportunity to agree or object, disclosures for specific public priorities such as public health or where required by law, disclosures that are incident to a permitted use or disclosure, disclosures regarding limited data sets, that's usually for research purposes, and disclosures as authorized by the individual. I'm going to just give a brief overview of the HIPAA security rule. So the HIPAA security rule establishes the requirements that covered entities and business associates must meet. It includes the consideration for flexibility of approach. It defines the required standards and implementation specifications, both required and addressable. It also requires maintenance of security measures implemented to support the reasonable and appropriate protection of electronic protected health information. So this just gives a brief overview of HHS's approach to the HIPAA security rule. The standards are to assure the confidentiality, integrity, and availability of electronic protected health information through reasonable and appropriate safeguards, addressing vulnerabilities identified through analysis and management of risk, and appropriate to the size and complexity of the organization and its information systems, and also it's designed to be technology neutral. So what is covered? So the security rule applies to electronic protected health information that a covered entity or business associate creates, receives, maintains, or transmits. And I just want to point out the distinction between the privacy rule and the security rule. So the privacy rule applies to all forms of protected health information. The security rule specifically applies only to electronic protected health information. And then also, we have the breach notification rule here. So under the breach notification rule, covered entities must notify each affected individual of a breach of unsecured protected health information. Notice to the media must also be given if more than 500 people were affected. Notice to the secretary of the breach must also be given through OCR's website. Notifications are to be provided without unreasonable delay, but no later than 60 days of discovery of the breach. Business associates also must notify covered entities of a breach and identify the individuals affected. An example of a breach of unsecured protected health information could be an employee had a laptop that was not encrypted and they left it in their car overnight. Someone broke into their car, stole the laptop, those sorts of things. So what is a breach? It's the acquisition, access, use, or disclosure of protected health information in a manner that is not permitted under the privacy rule, which compromises the security or privacy of the protected health information. So the presumption is that it is a breach unless a covered entity or business associate can demonstrate a low probability that the protected health information has been compromised based on at least the following factors, and that includes the nature and extent of the protected health information. Sometimes social security numbers are compromised, addresses, things like that. The person who used or received the protected health information, whether the protected health information was actually viewed or acquired, and the extent that the risk has been mitigated. And so now I just want to briefly touch on some HIV, civil rights, and HIPAA enforcement highlights. You know, the privacy rule does not make a distinction between protected health information that relates to specifically to HIV and other protected health information. It just covers all protected health information. That said, we do have a couple of cases that specifically involved HIV status. So this one in particular was in Massachusetts General Hospital, and we reached a settlement agreement with them in the amount of $1 million in an effort to settle potential violations of the HIPAA privacy rule. So the incident giving rise to the agreement was a loss of protected health information of 192 patients of Massachusetts General's Infectious Disease Associates outpatient practice, and this included patients with HIV/AIDS. Our office opened its investigation of this hospital after a complaint was filed by a patient whose protected health information was lost on March 9th, 2009. Our investigation indicated that the hospital failed to implement reasonable, appropriate safeguards to protect the privacy of protected health information when it was removed from the hospital's premises and impermissibly disclosed protected health information, potentially violating provisions of the HIPAA security or privacy rule. So this particular impermissible disclosure involved the loss of documents consisting of a patient's schedule, which contained the names, medical record numbers for a group of 192 patients, billing and counter forms containing the name, date of birth, medical record number, health insurer and policy number, diagnosis and name of providers for 66 of those patients. So this is another case. This is San Augustine, where a medical provider in California, he practices neurological surgery in Monterey Park, California. He participated in the Medi-Cal program, and because he participated in the Medi-Cal program, he received federal financial assistance. And as a recipient of federal financial assistance, as Michael touched on, he was prohibited from discriminating against any qualified handicapped person. Examples of prohibited discriminatory actions include denying an individual a service or other benefit provided under a program that receives federal financial assistance from the Department of Health and Human Services. So Dr. Augustine violated Section 504, which prohibits discrimination, again, on the basis of disability, because he refused to provide medical services to an individual based on that person's disability by refusing to provide services solely based on their HIV status. So the patient was HIV positive. The doctor refused to provide health services to this individual. Dr. Augustine's compliance with Section 504 could not be secured by voluntary means, and so therefore his receipt of federal financial assistance was terminated. Thereafter, he did enter into a post-termination compliance agreement with OCR to ensure his future compliance with Section 504. I just want to point out that this type of case is very rare. We very rarely pull federal financial assistance. Under our enforcement reg, we are required to try to obtain voluntary compliance with our regs. But in the case that we are unable to achieve voluntary compliance, we do have the ability to pull federal financial assistance, and in this case, unfortunately, that is what we had to do. So lastly, I just want to touch on our National HIV/AIDS Compliance Review Initiative. So on July 14th, 2016, we released a report on our National HIV/AIDS Compliance Review Initiative. This initiative was initiated in 2014 and 2015 when OCR conducted coordinated compliance reviews at 12 hospitals. So essentially, we had one hospital in each of the 12 cities that were most impacted by HIV/AIDS, such as Atlanta, Baltimore, Chicago, Dallas, Houston, Los Angeles, Miami, New York, Philadelphia, San Francisco, San Juan, Puerto Rico, and Washington, D.C. So essentially, we just looked at the hospitals. We saw some areas where they were doing really well. We saw some areas where they could improve their provision of services, and we just offered technical assistance to the hospitals to ensure that they are fully complying with the applicable regs. And then lastly, we have our website. We have the full text of the privacy, security, and breach notification rules. I know I just gave a very brief overview in the consideration of time. We also have the HIPAA privacy rule summary. We have a lot of technical assistance, frequently asked questions on our website, fact sheets, and additional information about our enforcement activities on our website as well. And that's it.
Thank you, Michael, Megan. We also have a colleague from OCR with us today in the audience, Eric Press. Eric, where are you? Say hi. So OCR is truly in the house today. Thank you for dedicating your time and coming out to talk to us. Next, I'm going to have Paula Perlman present on the work of the California Department of Fair Employment and Housing, followed by Angela O after that.
Good morning. So my slideshow is not in your materials. I apologize. I can email it to anybody. You can email me directly. All the DFEH addresses are first name dot last name at dfeh.ca.gov, and I'm Paula.Perlman at dfeh.ca.gov. So it's my pleasure to be here, especially when I was at the Disability Rights Legal Center. We were one of the founding organizations with the Williams Institute and the LA County Bar Association AIDS Legal Services Panel, starting the LA HIV Law and Policy Project. So it's very cool to continue doing this work here on behalf of the people of the state of California at the California Department of Employment and Housing. So basically I want you to understand a little bit about the laws that we enforce and our processes and our procedures. My colleague Angela O, who I'm completely firewalled from and has no idea what I'm working on unless I have a mediation pending with her, just so you know, that the enforcement in the legal division, and something that's unique to California, the DFEH, is we can file something called director's complaints, very similar to what our OCR colleagues were talking about, where if you believe discrimination is occurring, you can. They do an audit, we can file, we call it. So our mission, we are the state's Fair Employment and Housing and Civil Rights Agency. We have police power. We receive, investigate, conciliate, mediate, and prosecute complaints in the areas of employment, housing, public accommodations throughout the state of California. We're headquartered in a place called Elk Grove, which is about a half an hour outside of Sacramento, because I believe the rent is cheaper. Lest you will think that the state is squandering resources. We are not. And then we have 5 offices also in Los Angeles, Fremont, which is in the Bay Area, Fresno, Bakersfield, and Elk Grove. The interesting thing about the DFEH is we're very jurisdictionally based. In private practice, you can say, that sounds good, let's file that kind of case. For the state, we have jurisdictional limitations. So we can file cases and investigate cases under the Fair Employment and Housing Act, which is Government Code 12900, California Family Rights Act, which is the state equivalent of the FMLA. Unique to California is the Pregnancy Disability Leave Laws. The Under Civil Rights Act, which also enforces Title II of it. Well, it enforces the ADA, both Title II and Title III of the ADA. Under 51F of the Under Civil Rights Act, we have jurisdiction to enforce the ADA. So it's a very powerful tool. We also do the Disabled Persons Act and the Raw Civil Rights Act. There's a bill pending right now sitting on the governor's desk to give us authority and jurisdiction to enforce Government Code Section 11135, which is if you receive state financial assistance, just as our OCR colleagues enforce the law if there's federal financial assistance. This one is if you receive money from the state, either a state contractor, a health clinic, anybody receiving a contractor, anybody receiving state money, hopefully the governor is going to sign the law. It was ours. He ran it, his office ran it, so we should be able to have that authority and jurisdiction. We have no interest in your immigration status whatsoever, so it doesn't matter if you're documented or undocumented. We will investigate your complaints. So, sort of briefly, what happens is a complaint is filed. We also have an online portal, or ourselves that it hasn't occurred. Individuals can file a complaint, you can file a group or class complaint, and we have a special unit that does systemic litigation. So, for example, we sued the LSAT folks, the LSAC folks, for not accommodating test takers with disabilities. They were not using the best insurance standard, and that resulted in a complete change in how the LSAC is having accommodations. And they also were entitled to attorney's fees and costs, and we received approximately $900,000 in attorney's fees for that work. We have another case pending right now against a subprime lender for car loans. He charges women more money, women of color more money, and co-signers who have a woman co-signer more money. So that's a violation of the Under Civil Rights Act, and that's came out of our systemic litigation unit. So basically, a complaint is filed, and then it gets investigated. It gets investigated by our enforcement division. Lawyers get involved with investigation of cases in this case rating system, where we're trying to identify really good cases that have a big impact, or cases that are just there's a clear violation. And what are we going to do about it? And so we have this star system, case rating 1, 2, and 3-star cases. For some of the director's complaints, the lawyers are investigating directly. You know, it's just keeps everything remains more confidential in terms of attorney work product. Everything we do is subject to transparency, Public Records Act requests, so you can get a copy of our investigation once it's closed. All of our policies and directives are online, including our Public Records Act requests.
We have like 9 people that just do Public Records Act requests. We get about more than 100 a day. So it's outrageous. I want those legal analysts to be my paralegal. No, they're responding to Public Records Act requests. Guilty. Yeah, I was thinking about that actually, and we're getting a new case management system. So right now, I cannot search the basis of disability. So I couldn't tell you today how many HIV cases we have because our system doesn't do it. But we're contracting, we're getting a new case management system, and that was one of the first things that we did, all this like wind tunneling and meeting, what do we want? We want to know. We want at the granular level, what kind of cases are being filed, who's filing them, and where are they being filed, so we can be more proactive in the work that we do. So once it gets assigned, it's investigated, it will get assigned to a lawyer, and then if we believe there's cause, then it will get referred to legal. And once it's in legal, we have a mandatory mediation that Angela is going to speak about. We also have some prosecutorial discretion. Sometimes we'll go to mediation, but we'll decide not to file a lawsuit. But in housing, we have like no prosecutorial discretion if it's jointly filed with HUD. And then we file lawsuits. When people ask me, what do you do, Paula? I go, I file lawsuits on your behalf. I file lawsuits on behalf of the people of the state of California. We are the plaintiff. And the individual complainant is a real party in interest. They're essentially a percipient witness to the discrimination. And I don't even always need that if I have a director's complaint. So it's a very powerful tool to eliminate discrimination in the state. So even though the state is a huge bureaucracy, it's been quite an adjustment to work for the state. But the agency itself, the DFEH, is incredibly nimble. And we can open an investigation, we can start doing legal work almost immediately. There's no barriers to that other than time and energy and personnel. So we're a small division within the DFEH. We have 1 chief counsel. I mean, we don't even have 20 lawyers, but we act like we're really big. Because we, that never stopped us, what? And we have this really wonderful thing of their honored graduates. These are like graduate legal assistants. They're fellows who finish law school. They work for us for a year and then they go on. So basically we're a little group of lawyers doing a lot of work. This is And everything, really, I'm saying to you that you can accept my silly anecdotes and stories about the inside at the DFEH. You can find on our website. It's really comprehensive. It's actually accessible for people with disabilities, just so you know. We also have an ADA coordinator. As of yesterday, I stopped being that person. Yes. Because why it's good is that means we have other internal expertise in the organization who can now address accessibility complaints so people with disabilities can access our services. You can also, we have regulations that say if there's a need for expedited services because of the nature of someone's disability, their complaints can be expedited. So we're trying to be as nimble as possible using the limited resources that we have. So I want to talk about both employment and housing. It's illegal to discriminate, which means to refuse to hire or employ or do anything like that because somebody is part of a protected category. And the bases under FEHA these are race, color, national origin, sex, sexual orientation. For our purposes, it's disability, which includes HIV/AIDS, physical disability, mental disability, gender identity. DFEH just issued a new guidance on rights of transgender persons. There's a really great little graphic that came out the other day on this listserv, and it's a picture of a bathroom, and it's instead of male, female, it says, "Who cares?" Right? That was pretty cool. But we have more protected bases than Title VII. We have marital status, ancestry, military and veteran status. We have express protection for gender identity and gender expression, and we have new regulations that cover this. So most of our cases are disability, and after that it's retaliation, race and color, sex, and sex harassment. On our website, there's a new report. It's our 2015 annual report. It was issued June 2016. You can get all these statistics online, and you can get the last few years as well. This is sort of a very unreadable chart about here's the life of an employment complaint. But along the way, we're investigating, we're either finding cause and going forward, or we're not, and we give you a right to sue letter and we say good luck. And it's hard to say that. The lawyers are constantly going, how can I find cause? It's like, well, the law is limited. You know, every bad act is not discrimination, unfortunately, and we're limited with those requirements, and so that's just, that's what it is. I feel like my timekeeper's happening. The same with housing. What's interesting about housing is that it's all the protected categories and also any other basis covered under 504, the new Civil Rights Act. And what is really, I think, important for people to understand is there's a known or should have known requirement in all of this. So you may be HIV positive, but if nobody knows, then you're not going to have discrimination protection if nobody knows. There's got to be, because the discrimination has to be on the basis of a protected category. And if it's not known, if somebody didn't rent the house to you because you had bad credit, not because you're HIV positive, not because you're a woman, not because you're transgender. So there has to be a known or should have known element to it. And the difference in FEHA employment and housing is the familial status, like if you have children, your source of income that comes to you directly. There's some bad case that says if you get Section 8 housing, that income doesn't go to you, it goes directly to the landlord. So it doesn't prevent discrimination. It doesn't help you. It's got to be money that comes directly to you. These are UNRU bases. This is all on the website. What's interesting is immigration status, primary language, citizenship, sexual orientation. All of these, the ones at the bottom are new. But this California Supreme Court said, you know what? This is just, it's not a limitation. This is just general categories. So if you can think of something else that is similar to these but is not listed, there is potentially coverage under discrimination, intentional discrimination by a business establishment. Our housing, the primary issue is disability, mental and physical, retaliation, race, children, and source of income. Another unreadable spreadsheet. It's the same thing. There's no requirement to exhaust any administrative remedies. And you can, you end up being a real party in interest rather than a client. In LA County, this is among the highest number of complaints filed. It's employment, 6,100. Housing is 3,375. But you see the cases that actually get referred to legal, 73 employment cases got referred, and we filed suit on 27. 50 housing cases, this was last year, we filed suit on 17. And so we're working, I mean, part of it is the effectiveness of the mediation. We settle a lot of mediation. And part of it is a limitation on the number of lawyers, but I can tell you that we're working really hard to actually file more cases. I'm a litigator, that's what I do. I think it's fun. I know not everybody believes that and thinks that or feels that, but I think it's a very powerful tool to level the playing field, to equalize power among disenfranchised folks. And I think that that's our job. We do it, we're not cavalier. I don't want you to get the wrong impression. You know, willy-nilly we file cases. We really do believe that we've conducted thorough investigation. If we decide we have found cause and we're going to file a lawsuit, it's because we really found cause and we're going to file a lawsuit because there's real discrimination that occurred. And then you can see on our website some updates. These are new fact sheets on equal pay, our annual report. We have a brand new reasonable accommodation policy that we developed internally and we made public, so you can get that online, and it doesn't immunize you from liability, but it really goes through the process of a reasonable accommodation and how to do it well. And I think that's it for me. Thank you.
So we have limited amount of time, which is why you see me sitting antsy in my seat going, come on, come on. Thank you, Paula. That's great presentation. So next I'm going to have Angela come up. You know, I want to say that I really appreciate you coming today, Angela. I want to make a special note here because we find that a lot of our callers really don't have the energy to sustain litigation, to be part of active litigation for a long period of time, in part because of personal capacity issues and financial issues and otherwise. So I'm really excited that you'll be talking to us today about alternative dispute resolution at DFEH.
Good morning, and I'm not going to be offended if you stand up and stretch. You've been sitting for an hour and a half, I think, or an hour. You can sit, stand, but just don't start talking. Let's see, where's that little clicker thing? So I'm a member of a division that's newly created when the law changed, and it was, the old way was, you know, the investigators actually did a lot of what we call conciliation. What has happened since the law changed in 2013, allowing the agency to file suit directly in court, both state and federal, they created this new division called the Dispute Resolution Division. So conflicts come up in these ways, you know, in the workplace. You all know what kinds of things can happen. These and many other things depends on personalities. In the housing arena, same thing, except it's more intense. I mean, the work that this agency does goes to the core of one's existence. It's the way you shelter yourself and your family, and it's what sustains you so you can be a responsible adult in society. Those two things get cut off, or one of them get cut off, and of course the consequences can be devastating. Conflict, in my opinion, and I've been through conflict on a lot of levels, individual, community, societal, international. I've looked at it closely, I've worked in it deeply. So it's not always bad, right? So, you know, when we talk about trying to resolve potential legal disputes, this is not a situation where one party's going to dominate in the mediation space. That is fast, it's easy, and it doesn't last. It's also not a compromise situation, which is very unsatisfying and doesn't tend to last very long. You can actually approach this sort of process, mediation, with a mindset of integration. So what that does is it invites creativity. Why do I love this as opposed to doing trial and litigation? Because it's not confined by rules of evidence and rules of civil procedure, things that you cannot consider because of, time. You can't reach back to when you had an event occur 10 years ago, even though it was a very significant event and could be a trigger and could have all kinds of impact for today. The rules of evidence wouldn't permit it. Mediation is wide open. It also invites you to do something that we don't get to do very much in modern society, because we've gotten so used to being in positions of having convenience dominate. We get lazy, right? And then everything becomes a win or lose proposition. It invites you to not think solely as being a, quote, winner, the sole winner. So mediation, this is where a person like myself assists the parties to define what are the issues of mutual concern and develop some options. It's private, it's voluntary. Arbitration is different. It's another form of ADR, alternative dispute resolution, but it designates a person who's going to make the decision. It's private, it's voluntary, often it's costly. We're creating right now in the legal system a situation where you've got a private justice system going on where people pay for their cases to be resolved, and the person who is sitting there in the role of the arbitrator makes a lot of money and I think has an internal conflict because the longer it takes, the more money they make. And some of them make upwards of $1,400 a day, okay? Litigation, it's a dispute resolution process on the other extreme, and it's public, it's involuntary, it also is very resource intensive and energy intensive. So here's what goes on at our dispute resolution division. It's a free, confidential service. When I do it privately, it's $450 an hour. That was 7 years ago. When I do it for the DFEH, it's free. You get my whole day, not 3 hours. When I set a case, it goes for the whole day. If we end in 3 hours, cool, go have lunch. But, all of the laws that Paula referred to come to us. And it's about preventing litigation. It's about educating the public about our agency and the laws in California, which are different than the laws in Mississippi. It provides a means to empower the disputants so that you guys become the ones that decide the road that's going to be taken, not you're neutral. I, by the way, don't really ever refer to myself as a neutral. In the day of Google, people check out who you are. Nobody comes in there thinking I'm neutral. I have a point of view, but what's of utmost importance is that I use my best efforts to be fair. And sometimes fairness looks like this, and sometimes it looks like this. So it depends. So it's an invitation to be creative in problem solving. DFEH pathways to our services. The complaint gets received. The investigator does an initial query of the parties. And if both sides say, yeah, we want to try and resolve early, then it gets referred to my division. And then after that, the chief of my division divvies up the cases among a dozen mediators up and down the state. This is pre-investigation, it's voluntary. It moves quick. Our staff contacts the parties just to explain what the mediation process is. And one thing that is unusual from private mediation, where no terms are on the table until the parties decide, in our mediations, one of the things that's required is affirmative relief. And that affirmative relief is you must have a component of training. You have to make sure you're posting. If there's a policy or protocol that's deficient, you're going to revisit it and revise it, and that becomes a part of the settlement agreement, which is an enforceable contract. So, let's see, what does this say? All right, so when there's a decision made by the legal division that they're going to go ahead and file a lawsuit, before they can actually file paper, they have to come to mediation. So it's sort of what we call a mandatory mediation process. And so then it's the last stop. The parties come in, and what's different now is It's not going to be presumed to be confidential, and it's not going to be presumed that any of the terms are going to be. We have something called a general release and waiver. That is pretty standard. It's like anything you know you could sue about, you have to give up. But when the legal division is involved, maybe not. There might be some protections that get negotiated for certain claims that are important to the individual. It ratchets up the intensity of the discussion, but it doesn't change the dynamics much. People still want to, at this process, resolve the dispute, so we usually get there, has been my experience. There's a firewall between legal and the dispute resolution division, so truly what Paula said earlier, I have no idea what's going on over there. I sat here and listened and learned a couple of things this morning, but we are not allowed to have any contact with investigators or legal team. In fact, I often caution the parties, if we don't succeed here in this conversation, you do not answer the question of an investigator what happened in mediation. The answer is, I'm not supposed to talk about it. There is a code section in the evidence code that says all communications that are directed at dispute resolution are confidential. There are some lawyers out there in my lawyer community that want to undo some of that. They want to find an exception to that. So far, we've succeeded as the mediation community to say, no, there are going to be no exceptions, because people disclose all kinds of things in mediation, and it is private. We promise them confidentiality, even as between the divisions within this agency. So I already told you about the voluntary mediation. What happens is when they come into voluntary mediation, everything is suspended. So the clock stops in terms of time, the statute of limitations, all of that comes to a stop while you're pending with us. If mediation doesn't work, then the case file gets sent back to the investigators. We call them enforcement division. And then the clock starts back up again. They send a letter out, and usually the responding party, the potential defendant, is told you got 21 days from the date of this letter to submit your responses to these questions. If it's a mandatory dispute resolution process, then the lawyers come in from DFEH. They're a part of the conversation. If confidentiality is negotiated and agreed upon, well, then the lawyers make a decision about whether or not they will sign off. Which is it, Paula? Do you sign off or not sign off if confidentiality is part of it? Or do you care?
It's case by case.
Case by case, okay. And the other thing is that here, if a settlement isn't reached, what is a foregone conclusion is you will be receiving a complaint and you'll be filing an answer shortly. I mean, there are cases, and I've seen a couple of cases where they've declined to go ahead and file, but that was because of things like the complaining party actually lied to us and we didn't find out until we got to mediation. Once a case is filed, there can also be mediation. I have a case right now that's pending. No, we're not going to respond. No, we're not going to participate. No, we did nothing wrong. Go ahead and file your lawsuit, thinking that a lawsuit wasn't going to be filed, and it got filed. Now I'm getting a phone call. I really would like to mediate this case, because any lawyer that you go to is going to ask for a $25,000 retainer at minimum to work against. So you might as well be talking to mediation. Okay, red flags for liability. So these are the things that you want to watch out for, some of the issues that get raised that can cause a respondent to be tagged and really have to deal with bigger headaches down the line. Being ignorant of what the law requires, especially in a state like California, where this is a very robust, dynamic environment. It's not like Mississippi. It is not like Alabama. It is not like any of these states where the protections for people who are on the margins of our communities don't exist, pretty much. This is a robust environment. The law is changing all the time. Cases are redefining what facts matter. You need to pay attention. So these are all the reasons why mediation works. It's pretty intuitive. I think the most important thing is it saves people's life energy. Because whenever you're in a state of negative stress, demand, conflict, it's sucks up your energy. Just think of the last time you had to yell at somebody and how you felt afterwards, right? So this is the data, total mediations that we conducted so far. 453, we've settled 251, so there's our percentage rate. The settlement amounts just to this point is at $3.5 million, okay? That's pretty good. So if you have questions, go to our website. And Anne-Marie Bellotti is my division chief. I always direct everyone to her because that's her job. That's what you get when you get promoted. Anyway, thank you.
There were so many things that were said today. I'm writing things down myself. I know sometimes the law seems like a big mystery, and you hear things and you think you understand things and you want to know more about things. And so I recommend folks that have questions to follow up with our panelists here, and also welcome you to contact us at LA Help. One of the things that was, I think, Paula, you said, was that not every bad act is illegal discrimination. And the key word there is illegal, right? So a lot of folks give us a call and believe that there's discrimination, and in fact feel that there's been discrimination. And so our role is to figure out, but is it illegal discrimination? And that's the key question. I have a couple of questions, but I know we're running out of time. Are there any questions from the commission?
Ayako, thank you so much for all your work. I'm a big fan of your work. This is a kind of long question, but I think it's very important to put in the right context. So we are living exciting times in the work on HIV and AIDS. Advances in science has confirmed the importance of antiretroviral treatment that brings sustainable viral suppression and the undeniable benefits for the individual and the community. A big challenge we are confronting is the large amount of individuals not receiving HIV care, thus not achieving viral suppression. A big factor in this issue is the exchange of medical information between agencies. At the same time that we are expanding opportunities for testing and learning HIV status, at the same time, we are confronting major challenges in regards to the exchange of medical information between agencies. When I refer about the exciting times, we're talking about getting to zero initiatives in regards to bringing down the number of new infections. But I have realized in the last 4 or 5 years working in the field, not only in terms of implementing routine HIV screening in primary care settings, but also in regards to linkage to care, retention in care, and engagement in care, is that a big factor is the legal concerns about that exchange of information between agencies. I understand that New York already did some changes at the statutory level to make sure that that exchange of information is within the requirements of HIPAA. Can you help us to see what we need to do in order to make easier and more comfortable the process of exchange of the information in HIV care setting?
I can, yeah, please, Mike. Well, I would say that in California, there are a number of organizations that have been working at the forefront about information exchange, precisely because, for example, when we were transitioning to expanded Medi-Cal and the need to kind of make sure that people get enrolled from what were other programs into that expanded Medi-Cal was really, really important. There were statutory changes that were made to be able to do that in an easy manner. But privacy and confidentiality being paramount, there were always conversations as well about how to protect the privacy and confidentiality of individuals. And so in those conversations at the legislative level, we've always kind of thought about how to balance the two. I have to say that I am impressed by advocacy organizations throughout the state that are working with state agencies, at least here in California, to make that happen.
So, and from the federal standpoint, for HIPAA, under the privacy rule, we talk about what are permissive. There are only 2 required disclosures under HIPAA, but there are permitted disclosures. The main one of those, as Megan mentioned, was for treatment, payment, and healthcare operations. So I do understand the concern, but I think one of the issues for us is we sort of set a baseline, and states like California, for example, as Iago mentioned, can actually have greater protections. So I think that's one way to sort of allay that. The other thing that the federal government has done is, as Megan also mentioned during her presentation, was we joined initiatives that are part of Health and Human Services, trying to get people connected, linkage to care quicker. So that was one of the initiatives that we worked on. I mean, OCR is a small part of that, actually, but you know, the entire Department of Health and Human Services is aware of that. But I think, again, you know, from the federal standpoint, we sort of set a baseline, and the states, and we know that the state of California actually does have greater protections and greater sort of privacy protections in this regard. So.
Okay, so we have time for only a few more questions, so I'm going to go to the audience. Please don't make Wen run in her heels. Come to her.
Susan helped me today.
Okay, Susan, thank you.
Thank you all for your presentation. A lot of really great information. I have been discriminated against in the workplace multiple times. I have been discriminated against as a renter, and you know, thank God we don't have to do that anymore. But so I certainly know what it means to be on that end. But I've also employed maybe 50 people in my 19 years as an employer, and so that means that people lie, and sometimes allegations are made. I've never been sued, thank God, so we knock on wood. So my question is really about the recourse once an individual files a complaint against an organization, which can be extremely disruptive and costly, and then you find out that it was a lie. So what is the recourse, or is that even considered? Because it tends to be more one-sided when someone makes an allegation.
I really appreciate your concern. I too was an employer. I get it. But we're objective fact finders. So I think the best thing that you can do as an employer is to provide as much information as you have available as soon as possible. So once a complaint is filed, you will get notice of it, and then you'll get a list of questions, both interrogatories that just, you know, questions that answer these questions, and requests for documents, and cooperate. Because the more you can provide to us to show that no wrongdoing occurred, the faster we can close your case. Sometimes you can hire a private lawyer. It's to respond to an investigation request. Not everybody does. Usually it's somebody within the organization who's responding to those individual requests of discrimination. And what you want to do is make sure that the person who is the alleged wrongdoer is not doing the responding, because then it has this appearance of not neutral, you know. The other thing is to do your own internal investigation. Something happened that brought a person to file a complaint, and it's such a cumbersome process for the DFEH. You file a pre-complaint inquiry online. You wait between 30 and 90 days before somebody interviews you. That gets filed and served, and so there's a tremendous amount of patience that is happening on the part of the complainant, and we are under-resourced. We just got money to hire 18 new investigators. You know, we brought in 4 in LA, and they're brand new. They don't know exactly what to do yet. So the process takes a lot of time. But I think the cooperation, also there's something called the tolling agreement for the statute of limitations. So sometimes it's like, look, if you don't think anything happened, then try and work with us, because it's to your advantage. The lawyers are not there going, oh, let's file on everything. We're not. 1, we don't have the resources, and 2, not everything is a real case. And for the vast majority, they're not. There's no wrongdoing that occurred. Somebody may not like the result, but it's not illegal discrimination. I don't know if that helps. Oh, and there's mediation. Like, immediately, you can conciliate.
Okay, so what I want to say to you I've seen that situation many times, actually. And so, you know, if you have a skilled mediator, which I believe you do now, because most of our mediators are experienced litigation and trial counsel that have been brought on since this division was created. So we will be able to evaluate pretty quickly, I think, in the process as we debrief with each side. And then it's an education process. Sometimes you have somebody who has really suffered and doesn't have the evidence that will support that. And that's where the skill of the mediation person comes in. They have to be able to tell a person, you don't have anything here. And you're harming yourself, and you're harming people that shouldn't be in this process, accused of these kind. I view it like this. There are two injured parties when I get a mediation case. There's the person who's brought the claim, but nobody likes to be accused of racism, homophobia, sexism, you know, sexual harassment. I mean, especially if they don't believe it happened, or they, you know, have some information that suggests this person has another motivation for filing this kind of claim. But all of that gets teased out in mediation, so you should request your own.
And it's free.
And it's free.
And you don't necessarily need to have a lawyer at that early stage. Right. You know, you don't need a lawyer. It's free. It will be offered to you immediately to conciliate before the investigation goes forward. And you have this opportunity to sit in a room and say, here's what I think happened.
And you don't have to worry about the subtext of, is this person making more because they're just lengthening this conversation? Or is this person got some other motive? You're going to cut a deal if we get to X point, which all of those dynamics play in this process as well, the mediation process.
So we're actually at time. We have one more person on our list, and then I'm going to ask everyone to wait till the break and ask your questions then. So I have Yolanda, and then we're going to have to move forward.
Good morning. Thank you for your presentation. You guys really seem, you know, intimately involved in the process, and that there's a true concern and care. And so I was just actually looking into civil rights, and for example, I have a young lady that I'm working with who is HIV positive but has lost her children due to the county. And she's unable to get answers. No one will speak with her, and oftentimes being disenfranchised, being African American and poor, you know, it's easy to dismiss those people when you have questions. But actually this young lady is smart. And so that's a concern. So my question to you is that if someone who's HIV positive were on the internet looking you guys up and thinking my civil rights were violated, what is your referral process and just relationships with other agencies? So a young lady who may need legal representation against, let's say, the county just for answers, what is that process like, your referral process?
Well, I have been the ADA coordinator, and I get all those phone calls because my name, email, and a direct dial number is on the internet.
Okay.
And so, and we're changing our website. We're adding Law Help California, lawhelpca.org to the website. Anyone who calls me directly either gets me or my assistant, and we are asking, where do you live? What's the nature of your problem? I can't give you a referral to a private lawyer. I can refer you to a nonprofit organization so that somebody with DCFS, if they took her children away from her, she had counsel. She had parents' counsel. She has a lawyer who was supposed to represent her interests.
Right.
Okay.
What I believe should be the case.
And
but
so
she's saying otherwise.
So she has to go back to that lawyer or the lawyer's lawyer. If she, I mean, she can always file a discrimination complaint with us alleging that the government entity, the county, you know, violated her rights on the basis of disability. And we enforce, through the Under Civil Rights Act, we enforce Title II of the ADA. She could do that. And then it would end up with me, and I would try and figure out what happened. But there are certain things that we just don't have jurisdiction to cover. And so I think it's up to, like, advocates like you move through, you know, you go up the chain and figure out who can you talk to, who can provide this young woman with answers so she can get her kids back.
Okay, so perhaps at the break you can maybe share some of those organizations with me.
Just go Law Help CA. All one word.
Also, please feel free to call our LA Help, our project. Our role is to really help with navigation and determining what is the area of law and who are the players in the field. Thank you.
Thank you so much. Please join me in giving them a round of applause. If you have any questions, please feel free to walk up to them and ask them questions during the break.